My quiz on California legislation drafting to test your knowledge about drafting of legislation in the state. So question one, the Legislative Council provides legal advice to the legislature, the governor, and the remaining constitutional officers. That's false. The Office of Legislative Counsel provides services to, of course, the legislature, but also the governor, but not the other constitutional officers. Question two, the Legislative Council's digest provides a policy analysis of the bill's provisions. This is false. The digest is an objective description of existing law and what the bill proposes to actually do to existing law. Question three, a bill that has been keyed fiscal by the Legislative Council must be voted on by the Appropriations Committee. This is false. The bill will be re-referred to the Fiscal Committee, but does not have to be voted upon. The committee could waive review, or such as under Senate Rule 28.8, can simply send the bill to the floor if the committee determines that there are negligible state fiscal impacts. Question four, a spot bill always includes legislative intent language. This too is false. Spot bills contain non-substantive or technical changes to an existing statute, whereas an intent bill contains legislative intent language. Describe the differences among bills, resolutions, and constitutional amendments. Well, bills, of course, enact statutes. Resolutions are used to express the view of the legislature, and there are three types: a House resolution, a joint resolution, and a concurrent resolution. And then a constitutional amendment will place a proposed measure before the statewide ballot to add, amend, or repeal provisions of the state constitution. Question six, the Legislative Council's digest has four keys. That's true. They are the vote requirement, whether or not the bill contains an appropriation, whether or not the bill should be re-referred to the Fiscal Committee, and whether the bill contains a state-mandated local program. Question seven, the Office of Legislative Counsel determines whether a bill should go to the Fiscal Committee pursuant to Joint Rule 10.5. And that is true. And all of the digest keys are determined by the Office of Legislative Counsel. Question eight, a bill keyed as a tax levy is a tax increase bill. Perhaps one of the most common misunderstandings. It is false. While a tax levy is usually a collection tool used by the government, in California legislation, a tax levy is any bill that changes the rate, base, or burden of a tax. So does it impose, repeal, or materially alter a state tax? If so, then the Legislative Council keys the bill as a tax levy, or notes that it's a tax levy, and that'll be indicated in the bill's title as well as the digest, not in any of the keys. Question nine, only urgency clause bills take effect immediately upon enactment. That's false. Under Article 4, Section 8C3 of the California Constitution, it says, statutes calling elections, statutes providing for tax levies or appropriations for the usual current expenses of the state, and urgency statutes shall go into effect immediately upon their enactment. Question 10, double jointing and contingent enactment are the same thing. False, also a common misunderstanding. Contingent enactment means there's a section in a bill that says that the measure will become operative only upon the enactment of another measure. Double jointing amendments are amendments to a bill providing that the amended bill does not override the provisions of another bill, or both bills propose to amend the same section of law in the same year of a legislative session. Question 11, the legislature may make no law except by statute and may enact no statute except by bill. Yes, this is a verbatim quote of Article 4, Section 8B. Question 12. An urgency statute must include a statement of the facts constituting the necessity and of the urgency, and that statement must be in a separate section of the bill. That is true. A statement, this is pursuant to this Constitution in Article 4, a statement of facts constituting the necessity is required to be set forth in one separate section of the bill. Question 13. The title of the bill contains the subject matter of the bill. This is true. According to this according to the Constitution, a statute shall embrace but one subject, which shall be expressed in its title. Question 14. Special statutes are those that have uniform operation. That is false. All laws of a general nature have uniform operation. So a general statute versus a special statute. Question 15. Budget trailer bills must be listed by number in the budget bill. That's true. The Constitution says other bills providing for appropriations related to the budget bill shall consist only of bills identified as related to the budget in the budget bill that's passed by the legislature. Question 16. There are drafting rules found in the state constitution, the government code, the joint rules, the assembly rules, and the Senate rules. That is true. Each of these 5 documents contain rules or guidance for drafting legislation in California. Question 17. The California codes contain statutory interpretation provisions. That's true, and most of these are contained in the preliminary or the general sections, which is usually found at the beginning of most of California's 29 codes. Question 18. California statutes are presumed to apply retroactively as well as prospectively. This is false. They're presumed to operate prospectively unless there's clear evidence that the legislature intended the statute to apply retroactively, and this is pursuant to a number of California Supreme Court decisions. Question 19. The joint rules of the Assembly and Senate require inclusion of a relating clause in each bill. That's false. That's actually a constitutional amendment. A constitutional requirement. Question 20. All parts of a bill must be reasonably germane to a common theme or subject, which is commonly known as the single subject rule. And that, of course, is true. This is set forth in the Constitution. Question 21. If a statute would require a city or a county to conduct a new program or provide a higher level of service to an existing program, this may be a state-mandated local program. That is true, which is found in Article 6 of the California State Constitution. Question 22, a statute enacts only codified provisions of law. That's false, because a statute enacted by the legislature can enact both codified and uncodified provisions of law. Question 23, chaptering out refers to when a later enacted statute chapters out or repeals an earlier enacted statute from a different legislative session. That's false, because chaptering out applies when there are 2 or more statutes enacted that amend the same code section in the same legislative year of a 2-year session. And the last question, question 24, like most other states, California bills require an enacting clause. The people of the state of California do enact as follows, and this is found in the state constitution. That is false. It's the enacting clause requirement is actually found in the California government code.